Good afternoon, everyone, and welcome back. I'm Victoria Green. I will be chairing today's session. And for those who didn't see me last time, I'm a senior barrister at 1KBW. I specialise in all aspects of children law, many years' experience in both private and public law children cases. This is part of our 1KBW series of Going Beyond the Threshold. We are going to be looking at issue of habitual residence and jurisdiction issues in public law proceedings, drawing in particular on the case of, I think it's the Wirral Metropolitan Borough Council against AZM and another. Tig Barwell O'Connor is joining me to deal with that particular issue and to talk through some of the key principles and the practical challenges that arise when there are issues of jurisdiction that come into play. Tig practices across the full spectrum of family law, including public children law proceedings, acting for all parties, local authorities, through to guardians, parents, other family members. And as you may gather from what Tig is going to talk to us about, Tig has a practice that does also focus very much on international issues. So, Tig, I will hand over to you.
Thank you, Victoria. So, of course, we all know that courts need jurisdiction to make any of the orders, but normally that isn't going to be a problem for the vast majority of cases. When we think about where a child should be living, most of the time, for most of our cases that we're encountering, it's going to be somewhere in England and Wales. Obviously, we have those problems where it goes up to Scotland or to Northern Ireland, to our closer neighbours. And I think one of the helpful ways to think about issues of jurisdiction internationally is actually in the way that there can be one parent who lives in one local authority area, another in another, and perhaps the child is living with the grandma in a third. And those local authorities all have to work out who's going to be doing what, who's going to be footing the bill, lots of those sorts of issues. This is a similar problem, but it's done at the state level, at the nation level, rather than at local authority. So trying to work out which country has to make the decisions for a child is covered under Hague 1996, the convention, and it looks at Article 5 specifically. And in the way that it's applied in England and Wales, we have a factual determination as to a child's habitual residence. Lots of the precedents say we don't want any glosses, we don't want anything complex, it's just where is this child integrated? And the test that they sort of use, the phrase that's used, is the place which reflects some degree of integration by the child in a social and family environment. Now, some degree, it's not really a definitive phrase, and so it's really open to very significant judicial interpretation. There are a series of factors that courts can look at, and some will be relevant for some cases and others not in others. But they look at things like the duration of a stay that a child has been here, the regularity of that stay, the conditions, where they're living, with whom, how stable is that? The stability is often quite important. There's also what planning went into the family's move to the state. Was it last minute? Was it really, with lots of extensive plans put in place? Did everyone move at the same time as well? Child's nationality, the place and conditions of attendance at a school or other educational environment, likewise extracurricular activities, and the linguistic knowledge. So do they speak a language which other people around them also speak? Not necessarily just English, could also of course be Welsh or other nations' languages, but also if they're in a particular environment, it might be the local language which is spoken there. And then finally, and often most importantly with particularly young children, it's the family and social relationships the child has within that state. Now, this changes when children are very, very young to when they get much older, and the courts take the view that young children are often much more reliant on their caregivers, and therefore their caregivers' integration into a state becomes by proxy the child's integration into that state as well. Now, one of the things I think we find most difficult within care proceedings particularly is you don't always know all this information when you're engaging with a child for the first time. All of us, we want that child to be protected as soon as possible. And you don't always have time to work out who the parents even are or who the caregivers are. If a child needs to be protected, we are going to be jumping in, the court is going to be jumping in to make sure that that has taken place. But that means sometimes we miss that jurisdictional question of where is this child habitually resident? And so what is the legal basis for us taking these really important steps to protect a child? The reason why those steps are so important are because we don't want to have warring orders in different locations. It's very important that we try to progress the ideal of comity between different courts, but also that we prevent forum shopping. And one of the ways in which I've seen this be relevant, particularly in care proceedings, is that in the differences, particularly with our closer geographical neighbours, of adoption. There's quite a significant difference in the way that we deal with adoption to other countries. And parents may try to get away from that in either direction. And where a child is habitually resident will be the court that then has that determination. Now, one of the things that's often missed when we think about this is the timing. What is the relevant point? And I know we've said we're going beyond threshold, but actually it's a similar issue. The point at which you issue proceedings, that is your point in time. It's not before, and it's not 6 months later if you're still in proceedings. It's at that moment in time. It's really, really clear. And what was so interesting about the case that we've spoken of, the Wirral Metropolitan Borough Council and AZM and others, is that in that case, there was a one-day-old child. Now, it has been said in different precedents before, particularly in ANA 2013 UK Supreme Court, that a child's habitual residence could change over the course of potentially even a single day, though in very rare circumstances. And here we sort of had a relatively novel case. It was a child who had only existed for a day. Now, prima facie, that might look like, well, if the child's only existed for a day, there's only one country they've been integrated to. But because they were so young, I think it was the local authority and the guardian's position was actually that child's habitual residence was very closely associated with the mother's. The mother had stronger links, they argued, to Romania or Austria. And therefore there was a contention about that. There were also older siblings who I believe were had been taken into care in a different country already. And so it fell to Mr. Justice Poole, and he made the determination that the child was habitually resident here, and therefore the courts had jurisdiction to make care orders here. And he did that because of the planning that the mother had taken, so that the birth in the UK was planned. She'd engaged in prenatal care in England as well, and she had social and family connections here. So at one day old, when the proceedings were issued, that was the point at which this child was habitually resident here. It was really important because those care orders needed to be carried through legally. What's interesting though is that he said, and this is perhaps most relevant for when we don't know things about habitual residence, even if she weren't habitually resident here, in the alternative, he would have found under Article 6.2 that her physical presence here meant that the court could make orders at that stage. And that's sort of overview of the issues with habitual residence and how it changes with different ages and different timings for children.
So, I mean, that's obviously looking at a case where it's a real emergency, urgent, the real sharp end often of what happens at the start of a care proceedings. Is there any difference then when we're thinking about these sort of issues in terms of those emergency orders and long-term orders?
Definitely. So luckily, whoever wrote the Hague Convention, who came up with the drafting of it, they understood, particularly for care, we don't have the leisure of time sometimes. And so Article 11 exists for you to be able to say, we don't know, we need to make this order done. Likewise, you've got Article 6.2 in the physical presence if we're not sure where a child might be habitually resident. At no point, in my experience, is a court trying to say someone issuing is trying to sort of get over, sort of undercut the system in some way. But a court needs to understand what is their legal basis. And in those situations, if you're not sure, the best thing to do is to simply state that. To say, we believe this child was habitually resident in England, in Wigan, or wherever it happens to be, but we may need more time to ascertain that. And if you flag that for the court, then the court knows that might be an issue. It can be kept on the issues list.
Transfers of proceedings, that's also
Yeah.
part of that picture.
So sometimes you make an emergency order. It can maybe be done under Article 11. And then as you go through, you may find out that the child may be habitually resident here, and then that issue falls away. But if the view is taken that actually the child is habitually resident somewhere else, let's just say for this purpose in Spain, then the process of seeing which court would be best to make a determination for that child then can take place. And under Article 8, that's where that process is. Unfortunately, it could take an extraordinarily long time. So if it's something that you think needs to be undertaken in a case, it needs to be started as soon as possible. No one's going to be angry if it starts early and in the end you don't need to go through it. That's absolutely fine. The times when I've certainly had judges who perhaps are not best pleased with everyone in the court is when we get almost to a final hearing and someone then go, oh, I think we might need to consider transfer of proceedings. Yeah. And they realise that's going to take months, because the process can be direct to the authority in the other state, but it can also be through their central authority.
And if there's a transient family, it's perhaps difficult to pin down their habitual residents, how does that play out in these public law cases?
Well, it's interesting because the courts, the precedents on this, they function, or they've covered two really distinct groups at opposite ends of the socioeconomic spectrum, because you've got those families that are fantastically wealthy and are moving around a lot, so much so that it can be really difficult for a court to determine who has jurisdiction. Again, in that situation, it's Article 6.2. At the other end of the socioeconomic spectrum, we often have people who are moving because they are refugees, they may be here under non-normalised routes, they may be moving around because of abuse or whatever it happens to be. And in those situations, suddenly a lot of the usual facts of a case can be much, much more confusing. And so getting in place as early as possible, as detailed as possible, a chronology of all of those different things, but taking into account the habitual residence factors we spoke about before, each of the different schools, each of the different places they've lived, and how long a period of time they've been there. Really important. But ultimately, it will be a factual determination for the court to make.
Yeah. So if in a public law case, a judge is determining that issue of jurisdiction about habitual residence early on in the proceedings, as should happen, and the judge comes to the conclusion that actually habitual residence isn't here,
they should ideally, in that instance, make a determination as to where they think habitual residence is. But if they say it's Spain, then it's going to be important that Spain confirms that as well, because what you don't want is a child to be ping-ponging back between two different locations. So then a request is made, and that is then secured. Then a determination can be made as to how the transfer of this child going back, or whether the child will stay here whilst proceedings may be completed in the other location as well. Likewise, it's something whereby there have been a few cases where a judge has made a determination of habitual residence at the beginning, but as new information comes to light, that may need to be reviewed, and it can be reviewed. It's not that it was wrong at the beginning, it was just that was the information that was available. So again, if there are any concerns, it's better to raise them and have a discussion about it. Make sure that everything that's going forward is on a stable footing, than for it to be, unfortunately, become an issue at the very end of proceedings.
So what about interim protective measures if the court's decided there isn't jurisdiction here?
So the situation in which this seems to most often arise is when there are questions as to whether a child's been abducted to this jurisdiction. So often in that situation, we may actually know that a child is habitually resident elsewhere, or it becomes apparent during proceedings, but a local authority has had to jump in and take steps. Often, in the case law that's available, they've done so as normal under the Children Act, because they thought that the child was habitually resident here, entirely understandably. But when it becomes clear the child is habitually resident elsewhere, those orders technically have to be made under Article 5 of the Child Abduction and Custody Act. Now, what's most interesting about that article, it is incredibly broadly drawn. So it can include a local authority being directed to house, educate, care for, transport, clothe, feed, and provide healthcare for a child. And there aren't set parameters for that. There are only about 13 cases reported on that jurisdiction, and whether it has limits is something which is yet to be tested, but it's a really interesting area. So if a local authority thinks a child is here and is wrongfully here under Hague 1980, there is the real potential for there to be a very significant financial and time outlay for that child if whoever is in the High Court determines that is necessary in that case. It should be for a short period of time, but they can be very contentious and complex cases.
Well, thank you, Ty. That's yes, really helpful in terms of what are often quite complex issues in care proceedings. Very much hope that you'll be able to join us again for the next session, and indeed future sessions, which will continue to explore what we hope will be interesting and useful topics, challenging areas of public children law. Thank you.